The purpose and foundation of de jure government: protection of exclusively private rights. The main purpose for which all governments are established is the protection of exclusively private rights and property. This purpose is the foundation of all the just authority of any government as held by the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, but they are endowed by their Creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted among men, deriving their just powers from the consent of the governed. The fiduciary duty that a public officer who works for the gov has is founded upon the requirement to protect private property. As expressed otherwise, the powers are delegated to a public officer, are held in trust for the people, and are to be exercised in behalf of the government or of all citizens who may need the intervention of the officer. Furthermore, the view has been expressed that all public officers within whatever branch and whatever level of gov and whatever be their private vocations are trustees of the people, and accordingly labor under every disability and prohibition imposed by the law upon trustees relative to the making of personal financial gain from discharge of their trusts. That is, a public officer occupies a fiduciary relationship to the political entity on whose behalf he or she serves, and owes a fiduciary duty to the public. It has been said that the fiduciary responsibilities of a public officer cannot be less than those of a private individual. Furthermore, it has been stated that any enterprise undertaken by the public official which tends to weaken public confidence and undermines the sense of security for individuals' rights is against public policy. The very first step that any lawful de jure government must take in protecting private property and private rights is to protect it from being converted to public gov property. After all, if the people you hire to protect you won't even do the job of protecting you from them, why should you hire them to protect you from anyone else? The U.S. Supreme Court has also affirmed that the protection of private rights and private property is the foundation of the gov, when it held the following: the case below with a challenge to the constitutionality of the first national income tax, and the U.S. government rightfully lost that challenge. Here I close my opinion. I could not say less in view of questions of such gravity that they go down to the very foundations of the gov. If the provisions of the Constitution can be set aside by an act of Congress, where is the course of usurpation to end? The present assault upon capital theft and wealth transferred by unconstitutional conversion of private property to public property is but the beginning. It will be but the stepping stone to others larger and more sweeping, until our political contest will become war of the poor against the rich, a war of growing intensity and bitterness. Pollock versus Farmers Loan and Trust Company. Hearing the case against the first income tax passed by Congress that included people in states of the Union, they declared that first income tax unconstitutional, by the way. In the above landmark case, the lawyer for the petitioner, Mr. Schultz, even referred to the income tax as communism, and he has obviously right. Why? Because communism, like socialism, operates upon the following political premises. 1. All property is public property and there is no private property. 2. The Gov owns and or controls all property and said property is loaned to the people. 3. The Gov and other collective has rights superior to those of the individual. There is and can be no equality or equal protection under the law without the right of private property. In that sense, the Gov or the state is a pagan idol with supernatural powers because human beings are natural and they are inferior to the collective. 4. Control is synonymous with ownership. If the Gov controls the property but the citizen owns it, then the real owner is the Gov. The ownership of the property is qualified rather than absolute. The person holding the property is mere custodian over government property and has equitable rather than legal ownership. Hence, their name in combination with the social number constitutes a public office synonymous with the Gov itself. 5. Everyone in temporary use of said property is an officer and agent of the state. A public officer, after all, is someone who is in charge of the property of the public. It is otherwise a crime to use public property for private use or benefit. That crime is called theft or conversion. Public office, the right, authority, and duty created and conferred by law by which for a given period, either fixed by the law or enduring with the pleasure of the creating power, an individual is invested with some portion of the sovereign functions of government for the benefit of the public. An agency for the state, the duties of which involve in their performance the exercise of some portion of the sovereign power, either great or small, where by virtue of law a person is clothed, not as an incident or transient authority, but for such time it denotes durations and continuance with independent power to control the property of the public, or with public functions to be exercised in the purpose interest of the people, the service to be compensated by a stand yearly salary, and the occupant having a designation or title. The position so created is a public office. Public Black's Laws Dictionary, 4th edition. Look at some of the planks of the Communist Manifesto, Karl Marx, and confirm the above for yourself. 1. Abolish of property and land, and application of all rents of land to public purposes. 2. A heavy progression or graduated income tax. The legal definition of property confirms that one who owns a thing that is exclusive right to use and dispose of and control the use of his or her property and all the fruits and benefits associated with the use of such property. The implication is that you, as the private owner, have the right to exclude all others, including all govs, from using, benefiting from, or controlling your property. Govs, after all, are simply legal persons, and the Constitution guarantees that all persons are equal. If your neighbor can't benefit from your property without your consent, then neither can your so-called government. Property, that which is peculiar or proper to any person, that which belongs exclusively to one in the strict legal sense, and aggregated rights which are guaranteed or protected by the government. The term is said to extend to every species of valuable right and interest, more specifically ownership, the unrestricted and exclusive right to a thing, and the right to dispense of the thing in every legal way, to possess it, to use it, and exclude everyone from interfering with it. That dominion or indefinite right of use or disposition which may be lawfully exercised over particular things or subjects. The exclusive right of possessing, enjoying, and disposing of a thing, the highest right a man can have to anything, being used to refer to the right to which one has lands or instruments, goods, or chattels with no weight to depend on another man's courtesy. The word is also commonly used to denote everything which is the subject of ownership, corporeal or incorporeal, intangible, visible or invisible, real or personal. Everything has exchangeable value, time, or which goes to make up wealth or estate, and extends to every species of valuable right and interest, and includes real and personal property, easements, franchises, incorporated impediments, and includes every invasion of one's property rights by actionable wrong. Property embraces everything which is or may be the subject of ownership, whether illegal ownership or whether beneficial or private ownership. Term includes not only ownership and possession, but also the right of use and enjoyment for lawful purposes. Property within constitutional protection denotes rights of groups of rights, inhering a citizen's relation to physical thing as rights to possess, use, and dispose of it. In a lawful de jure government under our Constitution, 1. All persons are absolutely equal under the law. No government can have any right than a single human being, no matter how many people make up that government. If your neighbor can't take your property without your consent, then neither can the government. The only exception in this requirement of equality is that artificial persons do not have constitutional rights, but only such privileges as statutory law grants. 2. All property is exclusively presumed to be exclusively private until the gov meets the burden of proof on the record of the legal proceeding that you expressly consented in writing to donate the property or use of the property to the public. Men are endowed by the Creator with certain unalienable rights, life, liberty, and the pursuit of happiness, and to secure, not grant, or create those rights, governments are instituted. That property or income which a man has honestly acquired, he retains for control of, subject to these limitations: first, that he shall not use to his neighbor's injury, and that does not mean that he must use it for his neighbor's benefit, e.g. Social Security, Medicare, and every other public benefit. Second, that if he denotes it to the public use, he gives to the public a right to control that use. And third, that whenever the public needs require, the public may take it upon payment of due compensation. 3. You have to knowingly, intentionally donate your private property to the public use and public purpose before the gov can lawfully regulate its use. In other words, you have to at least share your ownership of the otherwise private property with the gov and become an equitable rather than a absolute owner of the property before they could acquire the right to regulate its use and impose obligation duties upon its original owner. 4. That donation ordinarily occurs by applying for and using a license in connection with the use of specific otherwise private property. 5. The purpose of applying for using a license and thereby converting private into public cannot be compelled. If it is, the constitutional violation is called eminent domain without compensation or stealing in violation of the Fifth Amendment taking clause. 6. You have public persona office and a private persona human at all times. That which you voluntarily attach a gov license number to, such as SN number or tax number, becomes private property donated to a public use to obscure the benefit of a public franchise. That property in turn is effectively owned by the gov grantor of your public persona and the public office it represents. If you were compelled to use a gov license number such as a SSN, a TIN, then a theft and taking without compensation has occurred because all property associated with such number was unlawfully converted and stolen. If the rights to contract of the parties conducting any business transaction has any meaning of it all, it implies the right to exclude the gov from participating in the relationship. You can write the contract such that neither party may use or invoke a license number or complain to a licensing board about the transaction, and thus the gov is contracted out of the otherwise private relationship. Consequently, the transaction becomes exclusively private, and government may not tax or regulate or abrogate the relationship in any way under the term of the license franchise. Every consumer of your services has the right to do business in those who are unlicensed. This right is a natural consequence of the right to contract and not contract. The thing they are not contracting with is the gov, and the thing they are not contracting for is statutory franchise protection. Therefore, even those who apply for gov license numbers are not obligated to use them in connection with any specific transaction, and may not have their license suspended or revoked for failure or refusal to use them for a specific transaction. If the gov invades the commercial relationship between you and those you do business with by enforcing their party to use to revoke the license number or pursue remedies or benefits under the license, they are interfering with your unalienable right to contract, compelling you to donate exclusively private property to public use, exercising unconstitutional eminent domain over your otherwise private property, and compelling you to accept the public benefit where the protection afforded by the license is the benefit. The above requirements of the USA Constitution are circumvented with nothing more than the simple presumption, usually on the part of the IRS corrupt judges who want to steal from you, that the gov owns it and that you have to prove that they consented to let you keep the fruits of it. They can't and never have proven that they have such a right, and all such presumptions are a violation of due process of law. Conclusive presumptions affecting protective interests. A conclusive presumption may be defended whether its application would impair a party's constitutionally protected liability or property interests. In such cases, such exclusive presumptions have been held to violate a party's due process and equal protection rights. In order to unconstitutionally and treasonously convert the above limitations in their rights to presume, corrupted govs and gov actors will play word games with citizenship and key definitions in the encrypted code in order to kidnap your legal identity and place it outside the above protections of the Constitution. By 1. Presuming that you are a public officer and therefore that everything held in your name is public property of the gov and not your private property. 2. Abusing fraudulent information returned to criminally unlawfully elect you into public offices in the gov. 3. Presuming that because you did not rebut evidence connecting you to the public office, then you consent to occupy the office. 4. Presuming that all of the four contexts for United States are equivalent. 5. Presume that constitutional citizens and statutory citizens are equivalent under Fed law. They are not. A constitutional citizen is a non-resident under Fed civil law and not a statutory national citizen of the United States at birth per 8 U.S. Code 1401. Presuming that nationality and domicile are equivalent, using the word citizenship in place of nationality or domicile and refusing to disclose which of the two they mean in every context. 8. Confusing the political constitutional meaning of words with the civil statutory context, for instance, asking on gov forms whether you are a political constitutional citizen and then falsely presuming that you are a statutory citizen under 8 U.S. Code 1401. 9. Confusing the words domicile and residence, or impute either to you without satisfying the burdens of proving that you expressly consented to it and thereby illegally kidnap your civil legal identity against your will. One can have only one domicile but many residents and both require your consent. 10. Adding things or clauses of things to the meaning of statutory terms that do not expressly appear in their definitions in violations of the rules of statutory construction. 11. Refusing to allow the jury to read the definitions in the law and then give them a definition that is conflict with the statutory definition. This substitutes the judge's will for what the law expressly says and thereby substitutes public policy for the written law. 12. Publishing deceptive gov publications are in deliberate conflict with that. The statutes define United States as then tell the public that they cannot rely on the publication. The IRS does this all with all of their publications, and it is fraud. This kind of arbitrary discretion is prohibited by the Constitution as held by the U.S. Supreme Court. When we consider the nation and their theory of the institutions of government, the principles upon which they are supposed to rest, and review the history of their development, we are constrained to conclude that they do not and mean to leave room for the play and actions of purely personal and arbitrary power. Thomas Jefferson, our most revered founding father, previously predicted the above abuses when he absolutely said, "It has long been my opinion, have never strung from its expression, that the germ of dissolution of our Fed government is the constitution of the Fed judiciary on irresponsible body for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step by a thief over the field of jurisdiction until all shall be observed from these states and the gov be consolidated into one. To this I am opposed. Contrary to the correct example, the Fed judiciary are in the habit of going out of the question below them to throw an anchor ahead and gabble further hold for future advances of power. They are then in fact the corpse of sappers and miners steadily working to undermine the independent rights of the states and to consolidate all power in the hands of the government which they have so important a freehold as state. The fiduciary of the United States is these little corps of sappers and miners constantly working underground to undermine the foundation of our Confederate fabric. They are construing our Constitution from a coordination of a general and special government to a general and supreme one alone. This will lay all things at their feet, and they are sure to well vested in English law to forget the maxim. Boni judices est complar jurisdictionem. When all governments, domestic and foreign, in little as in great things, shall be donned to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become as venial and oppressive as the gov from which we separated. What an argumentation of field for jobbing, speculating, plundering, office building, trader, business scam, and office hunting would be produced by an presumption of all the state powers into the hands of the general gov. The key to preventing the unconstitutional abuse of presumption by the corrupted judiciary and IRS to steal from people is to completely understand the context of the following memorandum of law and consistently apply it in every interaction with the gov. It ought to be very obvious to the reader that 1. The rules for converting private property to public property ought to be consistently, completely, clearly, and unambiguously defined by every gov officer you come in contact with, and especially in court. These rules ought to be demanded to be declared even before you enter a plea in a criminal case. 2. If the government asserts any right over your private property, they are presuming they are a legal owner and regulating you to equitable ownership. This presumption should be forcibly challenged. 3. If they won't expressly define the rules or try to cloud the rules for converting private property into public property, then they are defeating the very purpose for which they are established as a government. Hence, they are not a true government, but a de facto private corporation pretending to be a government, which is a crime under 18 U.S. Code 912. Exercising unconstitutional and eminent domain over private property without the consent of the owner, without compensation. Trying to steal from you and violating their fiduciary duty to the public. The right to be left alone. The purpose of the Constitution of the United States of America is to confer the right to be left alone, which is the essence of being a sovereign. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of a man's spiritual nature, of his feelings and of his intellect, they knew that only a part of the pain and pleasure and satisfaction of life are to be found in material things. They sought to protect Americans, their beliefs and their thoughts, and their emotions and their sensations. They conferred as against the government the rights to be left alone, the most comprehensive of rights and the right most valued by civilized men. The legal definition of justice confers that they purpose to protect your rights to be left alone. Justice as a moral habit is that tendency of the will and mode of conduct which refrains from disturbing the lives and interests of others and as far as possible hinders such interference on the part of others. This virtue springs from the individual's respect for his fellow as ends in themselves and as his co-equals. The different spheres of interest may be roughly classified as follows: body and life, the family or the extended individual's life, property or the totality of the instrument of action, honor and the ideal existence, and finally freedom or the possibility of fashioning one's life as an end in itself. The law defends those different spheres, thus giving rise to a corresponding number of spheres of rights, each being protected by a prohibition. To violate the rights to interfere with the interests of others is injustice. All injustice is ultimately directed against the life of the neighbor. It is an open avowal that the latter is not an end in itself, having the same value as the individual's own life. The general formula of the duty of justice may therefore be statuted as follows: do no wrong yourself, and permit no wrong to be done, so far as lies in your power or expressed positively. Respect and protect the right. Readings on the history and systems of the common law, second edition. The Bible also states the foundation of justice by saying, do not strive with or try to regulate or control or enslave a man without cause, if he has done you no harm. Proverbs 3:30. And additionally, Thomas Jefferson agreed with the above by defining justice as follows in his inaugural address: with all our bliss, what more is necessary to make us a happy and prosperous people? Still one thing more, fellow citizens: a wise and frugal gov, which shall restrain men from injuring one another, shall leave them otherwise free to regulate their own pursuits of industry and improvement, and shall not take from the mouth of a laborer the bread it has earned. This is the sum of good government, and this is the necessary to close the circle of our facilities. Therefore, the word injustice means interference with the equal rights of others absent their consent, and which constitutes an injury, not as any law defines it, but as a person who is injured defines it. Under the conception of justice, anything done with your consent cannot be classified as injustice or an injury. Those who are private persons fit in the category of people who must be left alone as a matter of law. There is a clear distinction in this particular case between an individual and a corporation, that the latter has no right to refuse to submit his books and papers for the exemption on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His powers to contract is unlimited. He owes no such duty to the state, since he receives nothing, therefore, beyond the protection of his life and property. His rights are such as existed by the laws of the land. Law antecedent to the organization of the state, and can only be taken from him by the due process of law, and in accordance with the Constitution. Among his rights are a refusal to the incrimination himself and the immunity of himself and his property from the arrest or seizure except under a warrant of the law. He owes nothing to the public as long as he does not trespass upon their rights. The Internal Revenue Manual, IRM, Section 514.10.2. Payroll deduction agreement. 2. Private employees, states, and political subdivisions are not required to enter into payroll deductions agreements. Taxpayers should determine whether their employers will accept and process executed agreements before agreements are submitted for approval or finalized. All right.